Welcome back to the Deep Dive. Today, we're embarking on a journey to explore something truly foundational, the very origins, the DNA, if you will, of intellectual property law here in the United Kingdom.
That's right.
Understanding where the law comes from is just so key to understanding why it operates the way it does today.
Absolutely. And it's important to mention up front that this deep dive is based on materials made available by the University of London for its students.
Yes,
As such, these materials and this deep dive are intended for educational purposes only.
absolutely. We're grateful for access to this material that lets us explore such a crucial topic. And we're also incredibly thankful that this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Mm-hmm. Their support makes these explorations possible.
It really is.
And, to all of you students out there, whether you're using this to supplement your studies or just deepening your understanding, we wish you the very best of luck with your exams and your learning journey.
Definitely. Good luck, everyone. Our mission today is pretty clear to unpack the key sources that have shaped UK IP law. We're
Yeah.
talking about international conventions, UK legislation, the significant influence of EU law, both historically and its lasting impact post-Brexit, and, of course, the vital role that case law plays in interpreting it all.
It's quite a mix.
It is. We've got a stack of sources here outlining these influences, and our goal is to really extract the most important nuggets of knowledge for you.
Think of this as building the base layer. While this topic itself might not be, the focus of every single exam question, the principles and the connections we make here are absolutely crucial.
Right.
For understanding everything else you'll study in UK IP law, patents, trademarks, copyright, designs, they all draw from these sources.
It's like learning the language before you read the literature, isn't it?
Exactly.
And because this is so foundational, we'll be intentionally revisiting and repeating some key concepts and names throughout our conversation. That repetition is key. Yeah, the goal is to help them really stick, giving you a solid framework for your studies.
We'll guide you through this, complex web of international treaties, domestic statutes, judicial decisions, highlighting what's truly essential.
Fantastic. So let's jump right in. When we look at the sources of UK IP law, the influence starts far beyond the UK's borders, doesn't it?
Definitely.
The source material puts a big emphasis on international conventions as a primary driver.
It certainly does. These global agreements often set the stage, providing the minimum standards or frameworks that, national laws must adhere to. They act as a significant catalyst for domestic legal change.
And at the heart of many of these conventions, particularly the older ones, is the World Intellectual Property Organization, or WIPO.
WIPO, yes.
Huh?
It's a specialized agency of the United Nations, headquartered in Geneva. It plays a critical role on the international stage.
Right.
The source highlights two main objectives for WIPO: encouraging IP protection, particularly in developing countries, and working towards the standardization of national IP laws globally. It also has an educational function, helping countries build their IP infrastructure.
So it's about fostering development and promoting consistency across different legal systems.
Pretty much.
WIPO also administers a multitude of international IP conventions, and the source categorizes these into three main types to help us understand their different functions.
Right. The first, and perhaps most fundamental category, are the protection treaties.
Protection treaties. Okay.
These are the ones that define the substantive rights that member states must recognize, set criteria for protection, and lay down minimum standards for domestic legislation.
So they tell countries what kind of IP they need to protect?
And to what extent, yeah. They set the baseline for the rights themselves.
Okay, protection treaties set the baseline for the rights themselves. What's the next category?
Then you have global protection systems.
Right.
These are less about defining the rights and more about streamlining the procedure for obtaining protection in multiple countries.
Because IP rights are territorial.
Exactly. Because IP rights are inherently territorial, a UK patent only gives rights in the UK. For example, you need a way to seek protection internationally. These systems offer procedural shortcuts.
So they make the process of filing in many countries easier, a bit like a one-stop shop.
Sort of, yeah. They provide a more efficient administrative route compared to filing separate applications in every single country.
Got it. And the third type?
Those are classification treaties. Their purpose is to standardize internal processes within national IP offices, like how applications are examined or how goods and services are categorized.
So administrative consistency.
Exactly. This brings a degree of administrative consistency globally.
Okay, so let's recap quickly. Protection treaties define the rights. Global protection systems simplify filing, and classification treaties standardize administration.
That's the gist of it.
Let's dive into the protection treaties, as these seem to directly influence UK law. The source highlights several key examples.
Yes, and the cornerstone for what's often called industrial property, patents, trademarks, and designs is the Paris Convention for the Protection of Industrial Property.
The Paris Convention, wow, dates all the way back to 1883.
It does, yeah. With the key revision for our purposes being the Stockholm Act of 1967.
Okay, what are its core requirements for member states?
Well, it obliges contracting states to provide protection for patents, trademarks, and industrial designs, as well as taking measures against unfair competition.
Right.
A basic requirement is that states must establish a national patent office and issue publications related to granted rights.
But the source pinpoints two absolutely crucial substantive rights introduced by the Paris Convention that are central to understanding international IP. We need to repeat and really understand these.
Yes, these are vital, really vital. The first is priority claiming, found in Article 4 of the Convention.
Priority claiming. Okay, this sounds critically important, especially for inventions. How does it work?
It provides a kind of grace period. So if you file an application for a patent, a trademark, or an industrial design in one Paris Convention member state, that filing date is called the priority date.
Right, your first filing date.
Exactly. You then have a specified period, 12 months for patents and utility models, and 6 months for trademarks and industrial designs within which you can file corresponding applications in other Paris Convention member states.
12 months for patents, 6 for trademarks and designs, and the magic of priority claiming is?
When you file those subsequent applications in other countries within that priority period, they are treated for the purpose of novelty and inventive step for patents or distinctiveness for trademarks as if they were filed on your original priority date.
Wow. Okay, so if I file a patent application in the UK today, let's say June 8th, 2025, the Paris Convention gives me until June 8th, 2026 to file for a patent on the same invention in, say, Germany, France, and China, and those applications will be assessed as if they were filed today.
Precisely.
Yeah.
That's exactly it. This is immensely valuable. It gives innovators and businesses time to decide where else they want to seek protection without losing the benefit of their initial filing date.
That makes sense.
And in the patent world, where novelty is paramount and there's often a race to the patent office door, priority claiming is absolutely fundamental.
Right.
It means that disclosure of your invention after your priority date, but before you file in other Paris Union countries, won't destroy the novelty of your later applications.
Okay.
We'll definitely see this concept again when we look at patents in detail. Priority claiming from the Paris Convention. Remember that one.
Got it. Priority claiming, a crucial right, especially for patents, giving a backdated filing date in other member states.
Oh.
What's the second key substantive right from the Paris Convention?
That's the principle of national treatment, contained in Article 2.
National treatment. This also seems incredibly significant for international trade and cooperation. What does it entail?
It's a principle of non-discrimination. Basically, every contracting state of the Paris Convention must grant the same level of protection under its domestic law to nationals of other contracting states as it grants to its own nationals.
Okay, so if I'm a U.S. company seeking to register a trademark in the U.K., under the Paris Convention, the U.K. has to treat my application and subsequent rights exactly the same way it would treat an application from a U.K. company.
That's the core idea. You get national treatment. You are treated no less favorably than a national of the country where you are seeking protection.
Right.
It's crucial to understand, as the source points out, what this doesn't mean, though.
Okay. What doesn't it mean?
It does not mean that the UK has to give the U.S. company the same level of protection it receives in the United States.
I see.
U.S. trademark law might be different from UK law. National treatment ensures fairness and equality under the law of the country where protection is sought.
Okay, so national treatment is about non-discrimination based on nationality, ensuring you get the same treatment as locals under their local laws, not exporting your home country's laws.
Exactly. So the Paris Convention covers registrable rights like patents, trademarks, and designs, mandates the establishment of national offices, and enshrines the key substantive rights of priority claiming and national treatment. It's the foundation for industrial property on the global stage.
That's clear. Now, shifting gears to non-registrable rights, particularly copyright. The primary convention here is the Berne Convention for the Protection of Literary and Artistic Works.
That's right. The Berne Convention dates from 1886, revised in Paris in 1971.
And this focuses specifically on copyright.
Yes, things like literary works, dramatic works, musical works, artistic works, films. It sets the criteria for the existence of copyright and determines the extent of protection that must be granted by member states. This convention has had a profound impact on UK copyright law.
Does the Berne Convention share that crucial principle of national treatment with the Paris Convention?
Yes, it does. National treatment is a common thread across many of these core IP conventions, and it's present in Article 5 of the Berne Convention.
So again, if you're a citizen of a Berne Convention country and your artistic work is used in the UK, you are entitled to the same copyright protection under UK law as a UK national would be.
Precisely. National treatment applies here too. Same principle, different context.
And is there a key feature of copyright protection under Berne, similar to priority claiming for Paris?
Yes, a really fundamental principle of the Berne Convention is found in Article 5. Copyright protection is not dependent on any formality like registration.
Ah, okay.
Protection arises automatically the moment the work is created, provided it meets the criteria for originality and fixation.
Automatic copyright protection, that's a significant difference compared to patents or trademarks, which typically require registration.
Absolutely. No forms to fill out, no fees to pay,
Hmm.
just for the basic existence of the right. It comes into being automatically upon creation.
That's a huge difference.
It really is. So, recap for the Berne Convention. It covers copyright works, mandates national treatment, and crucially, requires automatic copyright protection without registration.
What about rights related to copyright, often called neighboring rights, like the rights of performers or record producers?
Ah, yes, those are primarily addressed by the Rome Convention for the Protection of Performers, producers of phonograms and broadcasting organizations, which dates from 1961, often referred to as the Neighboring Rights Convention.
The Rome Convention. Okay. What specific rights does it cover?
It specifies the obligations of contracting states to protect performers regarding their performances, producers of phonograms, that's sound recordings, regarding their recordings, and broadcasting organizations regarding their broadcasts.
Right.
Like Berne, it sets criteria and defines the scope of this protection.
And does national treatment appear here as well? Predictable pattern here.
Yes, indeed. The principle of national treatment is also a feature of the Rome Convention. You see how this non-discrimination principle is woven throughout the international IP framework.
And is protection automatic, like in Berne?
Generally, yes. Protection under the Rome Convention is also not dependent on registration. However,
However.
yeah, there's a slight wrinkle. It does provide for the possibility of member states requiring a formality for sound recordings, specifically the display of a copyright notice, the little P in a circle symbol, accompanied by the year of first publication and the name of the right holder.
Okay, so the Rome Convention covers neighboring rights performers, sound recordings, broadcasts, includes national treatment. Protection is mostly automatic, but there's that specific formality for sound recordings that might be required by a member state.
That's the summary. Those three, Paris, Berne, and Rome, are often seen as the foundational WIPO protection treaties that directly influence UK IP law across its core areas: industrial property, copyright, and neighboring rights.
And the source notes that WIPO has continued to develop treaties to address new challenges, especially with, well, technology.
Right, particularly concerning the digital environment. The WIPO Copyright Treaty, 1996, and the WIPO Performers and Phonograms Treaty, 1996, often called the Internet Treaties. They update and supplement the Berne and Rome Conventions, clarifying how rights apply to the digital transmission and online exploitation of works and performances.
Makes sense. And more recently,
The Beijing Treaty on Audiovisual Performances, 2012, specifically extended protection to performers in audiovisual works, like actors in films.
there's also the Marrakesh Treaty for the Visually Impaired, 2013, mentioned. The source highlights this one as having a different kind of focus.
It's a significant departure in perspective, yeah. Most IP conventions focus on securing the rights of creators and right holders.
Right.
The Marrakesh Treaty, however, focuses on minimum protection for users.
Users. Interesting.
Yeah, it obliges contracting states to provide exceptions to copyright law to allow for the creation and distribution of accessible format copies of works for visually impaired and print-disabled persons. It's driven by social policy, access to knowledge, rather than purely economic rights for creators.
That's a really interesting contrast, shifting from protecting creators to ensuring access for specific user groups. What about the Universal Copyright Convention, UCC? This one is also mentioned.
Ah, the UCC, from 1952 and revised in 1971. It's another international copyright convention. It's notable because it's administered by UNESCO, not WIPO.
Okay, different admin body.
Yeah. Its subject matter is similar to Byrne, covering literary, dramatic, musical, artistic works, and films.
Does it also feature national treatment?
Yes, the principle of national treatment is present in the UCC as well. However, here's a key difference from Byrne.
Go on.
While Byrne requires automatic protection without formalities, the UCC requires the use of a copyright notice, that familiar E symbol, along with the name of the copyright owner and the year of first publication as a precondition for protection.
Ah, so under the UCC, affixing the A symbol is a legal requirement to get protection in member states, whereas under Byrne, protection is automatic even without it.
Precisely. That was a major difference between the two systems initially. The UCC was originally designed to facilitate relations primarily between former colonial powers and their colonies and dominions, ensuring reciprocal national treatment.
Right.
However, it's largely been superseded now, as most countries are members of the Berne Convention, which offers a higher standard of protection in many respects, particularly via that automatic protection principle.
Okay, that makes sense. That's a helpful overview of the key international protection treaties that set the stage. The source uses Activity 3.1 to prompt us to think about the key types of rights and obligations for Paris, Bern, and Rome as if we were making a table. Let's just quickly revisit those key points to reinforce them.
Good idea. For the Paris Convention, the rights covered are registrable industrial property patents, trademarks, designs, plus unfair competition. Obligations include establishing national offices and providing the key substantive rights of priority claiming and national treatment.
Got it. And for the Bern Convention?
It's copyright works. Obligations include providing national treatment and granting automatic copyright protection without formalities like registration.
Automatic protection. Key difference. Finally, the Rome Convention.
We have neighboring rights performers, sound recordings, broadcasts. Obligations include providing national treatment and generally granting automatic protection, with that specific formality possible for sound recordings using the entities.
That comparison is really useful for keeping them straight. Now, briefly, what about those other WIPO convention categories? Global protection systems and classification treaties. Just the basics.
Sure. Global protection systems, like the Patent Cooperation Treaty, PCT for patents, and the Madrid Agreement Protocol for trademarks are procedural. They offer a single point of filing that initiates the process in many member states.
Simplifying things.
Exactly, simplifying the administrative burden of seeking territorial rights globally. The source notes these are beyond the detailed syllabus, but are important to be aware of due to the territorial nature of IP.
And classification treaties like the NICE Agreement.
The NICE Agreement standardizes the classification of goods and services for trademark registration purposes. This standard classification is used by IP offices worldwide, including the UKP, which incorporates it into its process. It's an example of how these treaties streamline the administrative side of IP, makes things consistent.
Okay, so WIPO facilitates international IP in multiple ways, from defining rights to simplifying procedures. But the source introduces another major international body with significant IP impact, the World Trade Organization, or WTO.
Ah, the WTO. Established in 1994, part of the DT renegotiation. Its core objective is enhancing free trade globally.
Right.
The source points out that in some ways, the WTO, particularly through its key IP agreement, can be seen as a different kind of force compared to WIPO. Maybe even a rival force in some respects, as the source puts it.
Interesting. And that key agreement linking trade and IP is the Agreement on the Trade-Related Aspects of Intellectual Property, universally known as TRIPS.
TRIPS, yes.
Yeah.
It's a fundamental part of the WTO agreement, and all WTO members are bound by it. It's incredibly broad,
How broad?
containing provisions on all major categories of IP rights, patents, trademarks, copyright and related rights, industrial designs, geographical indications, layout designs of integrated circuits, and protection of undisclosed information. The whole lot.
Wow, covering the entire spectrum of IP. Does TRIPS also incorporate principles from Paris and Bern?
Yes, it explicitly incorporates fundamental principles from the Paris Convention and the Berne Convention, and even requires member states to adhere to the substantive obligations of the latest versions of those treaties. And crucially, TRIPS also adopts the principle of national treatment, as well as the principle of most favored nation treatment, meaning advantages granted to nationals of one country must be granted to nationals of all WTO members.
So TRIPS brings together IP standards from across the board under the WTO umbrella, reinforcing the older conventions. But what makes TRIPS particularly powerful, according to the source? Why the rival force idea?
Its most significant feature is its enforcement mechanism.
Enforcement. How so?
Unlike IPO treaties, which primarily rely on countries agreeing to implement standards through good faith and, diplomatic pressure, TRIPS links IP protection directly to the global trade system. If a WTO member state is deemed not to be complying with its TRIPS obligations, another affected member state can initiate the WTO's dispute settlement procedure.
Okay, a formal dispute process. And what can that procedure lead to?
Well, if the complaint is upheld and the defaulting state doesn't remedy the breach, the complainant state can ultimately be authorized by the WTO to impose trade sanctions against the non-compliant state.
Trade sanctions. Like tariffs.
Could be. Increased import quotas or duties on goods from that country. Real economic teeth.
Wow. That's a serious economic consequence. It sounds like that enforcement power is what distinguishes TRIPS and gives it real leverage to compel changes in domestic law compared to the WIPO treaties.
Absolutely. The threat of losing trade benefits has been a powerful incentive for many countries to upgrade their IP laws to meet the minimum standards set by TRIPS. It shifted IP more squarely into the realm of trade negotiations rather than purely cultural developmental policy,
Right.
which is part of why the source might see it as a rival force to WIPO in some ways. The focus is different.
However, the source also mentions criticisms of TRIPS. It's not universally loved.
No, definitely not. There are significant criticisms. One major concern is that TRIPS effectively globalized IP standards based heavily on the models prevalent in the US and Europe,
Okay.
potentially imposing these values on developing countries without sufficient consideration for their specific needs, economic realities, or existing legal traditions.
So it's seen by some as a one-size-fits-all approach that doesn't fit everyone.
That's one argument, yes. Critics argue it can hinder access to essential goods, like medicines, by strengthening patent protection and leading to higher prices, regardless of public health needs in poorer countries.
That's a serious concern.
It is. There are also concerns that it favors modern forms of IP, like technology and brands, over the protection of traditional knowledge, cultural expressions, or biodiversity that are important in many developing countries. Things that don't fit neatly into Western IP boxes.
That highlights a real tension, doesn't it, between the goal of standardizing IP for trade and the potential impact on development, public health, and cultural heritage.
It certainly does, and this leads into Activity 3.2, posed by the source, asking about the main differences between WIPO and WTO regarding IP and which mechanism is more effective.
All right.
As we've discussed, WIPO is more about cooperation and development, capacity building, while the WTO, through TRIPS, links IP directly to trade with that powerful enforcement mechanism. The source implies that this enforcement is what makes TRIPS generally more effective, or at least more forceful, at driving change in domestic law.
But that effectiveness comes with baggage, according to the criticism.
Exactly. The criticism suggests that while effective for standardization in the trade context, TRIPS might not fully account for the social and cultural values of developing countries due to its perceived imposition of Western IP norms and potential negative impacts, as highlighted by those criticisms mentioned in the source.
Okay, that's a nuanced picture. Moving to a regional level now, the source also discusses the Council of Europe. It's clarified this isn't an EU body.
Correct. Important distinction. The Council of Europe oversees the European Convention on Human Rights, but it's also been active in IP. The Strasbourg Convention of 1963 laid some groundwork, but the most significant convention for our purposes, stemming from the Council of Europe initiative, is the European Patent Convention.
The EPC. Yes, this is fundamental to how patents are granted that cover the UK.
Absolutely fundamental. The EPC was signed in 1973 and later revised into EPC 2000, which became effective in 2007. Its membership is broader than the EU. It's open to states that are members of the Council of Europe, plus some others.
And a key point, stressed by the source.
Yes, is that the EPC is not an EU legal instrument.
Okay, so the EPC system operates outside the EU's legal framework, no CJEU involvement.
Precisely. Decisions under the EPC are not subject to the jurisdiction of the CJEU, the Court of Justice of the European Union. This separation is important, especially when we consider Brexit later on.
Good point. So what is the core feature of the EPC system created by this convention? What does it do?
It established the European Patent Office, or EPO, located in Munich. And unlike national systems or even the PCT, which simplifies national filings, the EPC offers a system of centralized grants.
Centralized grants for patents. How does that work compared to filing nationally?
Well, you file a single European patent application with the EPO. The EPO examines it, and if it meets the patentability criteria defined in the EPC, the EPO grants a European patent.
One application, one examination by the EPO.
Exactly. This single grant then takes effect as a national patent in each of the EPC member states that the applicant designated in their application.
Ah, okay. So one application, one examination, and one grant decision by the EPO. But the result is a bundle of national patents, a UK patent, a German patent, a French patent, etc., rather than a single EU-wide patent.
Exactly right. The European patent isn't a single unified right across the territory, but a single process leading to national rights. And this is a crucial point. Once granted, a European patent covering the UK, what's often called a European patent, UK, has the same legal effect in the UK as a national patent granted by the UK's own Intellectual Property Office, the UKO.
That's vital for understanding the landscape of patents in the UK. So you can have a UK national patent from the UPPO or a European patent in the UK from the EPO, and legally they function identically within the UK.
Correct. They sit side by side. The EPO system essentially provides an alternative, often more efficient route to obtaining a patent in the UK and other EPC countries, alongside the purely national route via the UKPE.
And the EPO itself has judicial bodies, right? The boards of appeal.
Yes. The EPO's boards of appeal and enlarged boards of appeal interpret the EPC and handle appeals from EPO decisions. Now, while their case law isn't strictly binding on UK courts or the UKPU,
Right.
it is considered to be of persuasive value. Highly persuasive, in fact.
Persuasive, why?
Particularly when UK courts are interpreting parts of the Patents Act 1977 that were enacted specifically to implement the EPC. The UK law is meant to match the EPC in those areas.
Ah, okay. So EPO case law influences how UK courts understand and apply UK patent law, especially where the UK law mirrors the EPC. This brings us to how international conventions are actually implemented in the UK.
Yes, that's a fundamental point about the UK's legal system. Under UK constitutional principles, international conventions are not automatically part of UK domestic law.
They don't just become law here.
No. They don't create rights or obligations enforceable in UK courts unless and until Parliament passes specific legislation to implement them. Acts of Parliament are needed. Traditionally, UK courts would look only at the implementing UK statute, not the original convention text. The source mentions Lenzing AG's European patent as an example of this approach.
So Parliament has to actively translate the treaty into UK law.
Precisely. However, the source notes there's been an evolution in the judicial approach more recently.
An evolution. How so? What's changed?
Well, when UK courts are interpreting domestic legislation that was clearly enacted to implement or align with an international convention, like sections of the Patents Act 1977, which mirrored the EPC,
Yes.
they're increasingly willing to refer directly to the text of the original convention itself.
Why would they do that if the UK Act is the law?
To ensure the UK law is interpreted consistently with the international obligation it's supposed to fulfill. Cases like Airtel Ltd v. Telco Holdings Ltd Macrossen's application illustrate this shift. Courts use the convention text as an aid to interpreting the corresponding domestic legislation, especially where the UK law explicitly says it intends to have the same effect as the convention.
That makes sense if the UK law is meant to match the convention. Looking at the convention text seems a logical way to ensure that match is achieved in practice.
It's a pragmatic approach to interpreting statutes influenced by international obligations. Thinking about Activity 3.3, now the EPC and its key features compared to other conventions. The most striking difference is that centralized grant system via the EPO.
Right.
Paris, Bern, and Rome influence national laws or simplify national filing, like PCT, but the EPC system effectively takes the grant procedure out of the National Patent Office and centralizes it at the EPO, resulting in national rights post-grant. It's a unique beast.
That covers the major international and regional influences. So while treaties set the framework and the EPC offers a grant route, UK domestic law is where the rubber meets the road for rights enforceable within the UK.
Yes, United Kingdom legislation is the primary domestic source of IP law.
Yeah.
But as we've seen, these statutes don't exist in a vacuum. They are heavily shaped by those international and regional influences, and perhaps most significantly in recent history by EU law.
Okay. The source lists 4 principal UK statutes that form the backbone of this domestic IP law. Let's name and repeat those key pieces of legislation so they stick.
Okay, the core statutes are, first, The Register Designs Act 1949, which underwent a major rewrite in 2001.
Registered Designs Act 1949.
Got it. Second, the Patents Act 1977, with significant amendments in 2004.
Patents Act 1977.
Okay. Third, the Copyright Designs and Patents Act 1988, widely known as the CDPA 1988.
CDPA 1988, very famous one.
And fourth, the Trademarks Act 1994, subsequently amended.
Trademarks Act 1994. Okay, those four cover the main areas: registered designs, patents, copyright, and trademarks. How are they tied to those external influences we just discussed?
Well, the Registered Designs Act 1949, originally much older, was essentially rewritten in 2001 specifically to comply with the requirements of the EU Designs Directive,
Ah.
which aimed to harmonize design protection laws across member states.
So the modern version of the Registered Designs Act is a direct result of EU harmonization efforts.
Precisely. The Patents Act 1977 was enacted to fulfill the UK's obligations upon joining the EPC.
Right. We just discussed that connection.
Exactly. Its provisions on patentability criteria, for example, were specifically designed to align with the EPC. The 2004 amendments updated the Act to reflect the changes introduced by EPC 2000.
So the connection between the Patents Act 1977 and the EPC is really, really strong then, almost symbiotic.
Very much so. The CDPA 1988 is a bit different. It consolidated and reformed earlier UK copyright law and also enabled the UK to ratify the 1971 Paris Act of the Berne Convention.
So domestic consolidation plus Berne alignment.
Yes, but since its enactment, it has been extensively amended over the years to implement numerous EU copyright directives.
Okay, so the CDPA started with UK roots and Berne alignment, but became heavily influenced by EU law through subsequent amendments to hybrid.
Exactly. And the Trademarks Act 1994 was passed specifically to implement the EU Trademarks Directive and the EU Trademark Regulation, harmonizing and modernizing UK trademark law in line with EU standards. It has also seen subsequent amendments.
So it sounds like the modern UK IP statutes are largely the result of Parliament implementing obligations and standards from international conventions like Berne and the EPC, and especially from EU law.
Which leads to a crucial point about interpretation.
Mm.
Because these statutes are designed to implement or mirror external legal frameworks like the EPC or EU directives, UK courts and the UKPO are constrained in how they interpret them.
Constrained in their interpretation. What does that mean in practice?
Take the Patents Act, 1977. Section 130 of that act makes it clear that key provisions, particularly those relating to patentability and the scope of patents, are intended to have the same effect as the corresponding provisions in the EPC.
Ah, okay. Explicit linkage.
Yes. This places an obligation on UK tribunals, courts, and the UKPO to interpret the Act in conformity with the EPC.
And does that include considering case law from the EPO? We mentioned it was persuasive.
Yes, definitely. The source highlights that UK tribunals must take note of decisions from the ETO's boards of appeal when interpreting sections of the Patents Act that implement the EPC, particularly the criteria for patentability.
Right.
Cases like Merrill Dow v. Norton and Kieran Amgen Inc. v. Hocht Marion Roussel Ltd., where Lord Hoffman made significant comments on this point, illustrate this obligation to consider EPO case law when interpreting the Patents Act 1977.
So the UK statutes are the domestic law we interact with, but their meaning and application are deeply informed and sometimes limited by their origins in international law, retained EU law, and relevant case law from bodies like the EPO. It's not just about reading the UK Act in isolation.
Precisely. Which brings us neatly to the monumental influence of European Union law on UK IP. Between 1973 and the end of 2020, when the UK was a member state, EU law fundamentally reshaped vast areas of UK IP.
Right. And the source stresses that much of this influence remains post-Brexit. It hasn't just vanished.
Why did the EU delve so deeply into IP, given it's traditionally a national matter? What was the driver? As we touched on earlier, the driving force was the creation and functioning of the single internal market.
Free movement.
Exactly. National IP rights, by their very nature being territorial and subject to differing national rules, acted as barriers to the free movement of goods and services across member state borders.
How so?
They could be used to prevent imports of genuine goods that were legally put on the market in another member state, for example, fragmenting the market.
So differences in IP laws and their territorial effect could partition the single market the EU is trying to build.
Exactly. The EU needed to overcome this fragmentation. Their strategy involved two main approaches. First, harmonization directives.
Okay.
These are addressed to the member states, requiring them to amend their national laws to align on specific points of substance reducing differences, making national laws more similar.
And the second approach?
Second, the creation of pan-European rights through directly applicable EU regulations. These rights exist alongside national rights, but are valid across the entire territory of the EU member states through a single registration.
Okay, harmonize the national laws and create some EU-wide ones, too.
That was the plan. And the source makes it very clear that the vast majority of the changes implemented in UK law as a result of this EU influence are not being undone by Brexit.
They're sticking around.
Yes, they form a permanent part of the UK's legal landscape, unless Parliament specifically legislates to change them.
That's a critical takeaway. Much of the EU IP acquis, as they call it, is now embedded in UK law.
It really is.
Let's look at the harmonization directives first. Where did they have the biggest impact? Which areas?
They had a massive impact on trademarks, designs, and copyright. Their impact on patents was more limited, largely because the EPC already provided a regional framework outside the EU, as we discussed.
Right, starting with trademarks then.
The first trademarks directive in 1988, later codified in 2008, was a key harmonization measure. It focused on internal market aspects of trademark law, requiring member states to align their national laws on fundamental issues like what signs are capable of being registered as a trademark, the absolute and relative grounds for refusing registration,
Right.
the scope of protection granted by a trademark, defenses to infringement, and rules around licensing and loss of rights. Really core stuff.
And these requirements were directly implemented into UK law by the Trademarks Act in 1994.
Yes, the 1994 Act was passed precisely to implement this directive, fundamentally reshaping UK trademark law to bring it into line with EU standards. A newer directive in 2015 led to further changes implemented in the UK via the Trademarks Regulations 2018.
So UK trademark law is heavily harmonized with EU concepts and definitions. What about designs? Similar story.
Very similar. The Designs Directive of 1998 similarly led to significant partial harmonization for registered design law. It set common standards for the definition of a design, the key criteria for protection, novelty, and individual character.
Novelty and individual character.
Specific exclusions from protection and the scope of infringement, again, core aspects.
And this is why the Registered Designs Act 1949 was largely rewritten in 2001.
Exactly. The 2001 amendments completely overhauled the Act to comply with the requirements of the Designs Directive.
Right.
It's important to note, as the source does, that while registered design law was harmonized, member states were free to retain or introduce other forms of design protection under national law, like copyright or unregistered design right, which exist alongside the registered right in the UK, so it didn't wipe out everything else.
Okay, that's useful background. Moving on to copyright. The source notes the EU issued the largest number of directives in this area. Why so many?
Yes, they addressed various specific aspects of copyright and related rights to reduce fragmentation. It seems copyright was seen as particularly fragmented, or perhaps technology kept creating new challenges. Examples include the Computer Programs Directive, 1991,
Right.
which mandated copyright protection for computer programs, specifying these should be protected as literary works.
As literary works. Okay, that's specific.
Yeah. Yes. The Copyright Term Directives in 1993, codified 2006, and the Extension Directive in 2011 were crucial for standardizing the duration of copyright protection across the EU for authors and performers, getting everyone onto the same page regarding how long protection lasts.
Standardizing the length of protection across Europe seems like a major harmonization effort. Must have been complex.
It was. Other directives covered specific types of content, like the Database Directive in 1996, which created a unique two-tier system of protection for databases, involving both copyright and a sui generis right, a special right just for databases.
Okay.
The Information Society Directive in 2001 was also very broad, harmonizing the core exclusive rights of authors and right holders in the digital environment, and providing an exhaustive list of permissible exceptions and limitations to those rights that member states could implement.
So defining rights and also the limits on those rights.
Exactly, a balancing act. And EU law also aimed to harmonize the enforcement of these rights.
Enforcement.
Yes. The Enforcement Directive of 2004 required member states to provide a set of harmonized civil remedies for IP owners across all types of IP.
Civil remedies like injunctions and damages.
Yes, things like that. Although in practice, it's had the biggest impact on combating counterfeiting and piracy, especially for copyright and trademarks, providing tools for rights holders.
So these directives didn't create new types of IP rights as such in the UK, but they mandated significant changes to the national laws covering trademarks, designs, and copyright, making them look much more similar to the laws in other EU countries, leveling the playing field.
That's precisely their function. And critically, as we mentioned, all these directives were implemented into UK law through various statutes and regulations. Following Brexit, they remain part of UK law unless and until the UK legislature chooses to amend or repeal them. They're baked in now.
Got it. You mentioned patents had limited EU directive influence. What was the one key directive there?
That was the Biotechnological Patents Directive, 1998.
Ah, yes, biotech. Always controversial.
It was significant because it addressed the complex and sometimes controversial area of patenting inventions involving biological material, such as gene sequences or genetically modified organisms. Different member states had varying approaches and ethical considerations.
So what was its core aim? To allow biotech patents.
It aimed to clarify that biological material is patentable in principle if it meets the normal criteria for patentability under patent law, like novelty, inventive step, and industrial application.
But with limits.
Yes. It also included important exceptions, particularly on ethical grounds, such as prohibiting patents on processes for cloning human beings or modifying the germline genetic identity of human beings. It also spelled out specific infringement rights related to biological material.
So while the EPC handles most of patent law, the EU stepped in to provide clarity and some level of harmonization on this specific, sensitive area of biotechnology.
That covered the harmonization side. Now, the other prong of the EU strategy, pan-European rights.
Right. These are the ones that create a single IP right valid across the entire EU territory.
Exactly. Through a single application and registration process.
These sound different, actually, creating a new single EU-wide right, not just tweaking national ones. More ambitious.
You could say that, exactly. The source mentions 3 such systems, though only 2 are directly relevant for UK IP historically. The European Union Trademark, EUTM, and the Community Design. The third is the EU plant variety, right? Not on the syllabus.
The EUTM and Community Design. Okay, where were these registered? Not national offices.
No, these were registered through the EUIPO, the European Union Intellectual Property Office, based in Alicante, Spain. It was formerly known as OHIM.
EUIPO in Alicante. Got it. And were these directly applicable in the UK during EU mandate? Did Parliament have to do anything?
No, because they were EU regulations, they were directly applicable law in all member states, including the UK, without needing separate national implementing legislation.
Yeah.
A single EUTM registration granted by the EUIPO was automatically valid and enforceable throughout the EU, including the UK. Similarly, for the Community Design, one registration covered the whole block.
The source makes an interesting point about the case law on the Trademarks Directive, harmonizing national law, and the EUTM regulation, creating the EU-wide right. Says it's interchangeable.
Yes, this is helpful for students.
Yeah.
Because the substantive provisions of the directive and the regulation are often identical or very similar.
Right.
The case law from the CJEU interpreting one is usually relevant and interchangeable with the case law interpreting the other. The principles are the same.
Why would the CJEU interpret the directive if that was implemented nationally?
Through the preliminary ruling procedure. National courts in member states interpreting their harmonized national law under the directive could ask the CJEU for preliminary rulings on the meaning of the directive's provisions. Under Article 267 of the TFEU, this generated a huge body of authoritative case law on the meaning of the directive's provisions.
And the CJEU also interpreted the regulation. How?
Yes. Decisions from the EUIPO granting or refusing EUTMs or community designs could be appealed, ultimately reaching the CJEU on points of law. So whether interpreting the directive via national court reference or the regulation via an appeal from EUIPO, the CJEU provided consistent explanations of key concepts like distinctiveness for trademarks or individual character for designs.
So CJEU case law on either the directive or the regulation provides essential guidance for understanding the harmonized concepts in UK trademark law and the EUTM system itself. Basically, read the CJEU cases.
Definitely. Which brings us to the really significant event, Brexit, the UK's departure from the EU. The source details the legal changes that occurred particularly from 1st January 2021 after the transition period ended.
Right. The European Communities Act 1972, which was the basis for EU law having effect in the UK, was repealed.
Big change.
Huge change, yes. It was repealed by the European Union Withdrawal Act 2018, or EUWA 2018.
EUWA 2018. Okay.
This act was the primary legal mechanism for managing the transition of EU law into UK law and determining the status of EU institutions' authority post-Brexit. A key objective was legal certainty. avoiding a cliff edge. And how did the EUWA 2018 achieve that continuity? How did it keep things going?
Well, it created a new category of domestic law called retained EU law. This is crucial. It's specifically in Section 2 of EUWA 2018.
Retained EU law, what does that actually mean?
It essentially took a snapshot of EU law as it applied to the UK just before exit day and absorbed it into the UK's own legal system. This includes UK domestic legislation that was enacted to implement EU directives and also binding EU rules that had direct effect, like EU regulations.
So all those changes made by Parliament to implement directives and the substance of EU regulations like the EUTM regulation were essentially copied over and became UK law overnight on 1st January 2021.
That's the effect, yes. They are now part of UK domestic law, although subject to potential future amendment by the UK Parliament. This retained EU law concept is central to understanding the current state of UK law influenced by the EU.
What about the vast body of CJU case law that existed before Brexit, interpreting all that law?
That was also largely absorbed. Pre-Brexit judgments of the CJEU interpreting EU law, which forms part of retained EU law, were given a specific status under the EUWA 2018.
Okay, what status?
They are treated as authoritative sources, generally having the same binding status in UK courts as decisions of the UK Supreme Court. This is specified in Section 6, 3, and 7 of the EUWA 2018.
Wow, so pre-Brexit CJEU judgments interpreting this body of law are binding precedent for UK courts, just like Supreme Court decisions.
Yes, they're retained EU case law with binding status. However, yes, senior courts in the UK, specifically the Supreme Court, the Court of Appeal, and the Scottish High Court of Justiciary, were given the power under Section 644 of the EWA 2018 to depart from this retained EU case law.
They can deviate from it, but presumably not easily.
Exactly. The source notes and the Court of Appeal confirmed in TuneIn Inc. v. Warner Music UK Ltd. that this power to depart from retained EU case law should be exercised with great caution. That's required by Section 6.5 of the EUWA 2018. It's not a power to be used lightly, respect to the established law.
Okay, binding unless departed from, with great caution by top courts. And what about EU law or CJEU judgments that came after Brexit, from 1st January 2021 onwards?
Well, new EU legislation and new judgments in the CJEU delivered after the transition period are not binding in the UK. That's clear from Section 6(1)(a) UWA 2018.
Makes sense. Not part of the UK system anymore.
But there's a nuance here. Under Section 6(2) of the EUWA 2018, UK courts are permitted to have regard to post-Brexit CJEU judgments on matters that fall within retained EU law.
So they don't have to follow them, but they can look at them and consider them, find them persuasive.
Precisely. They can find them persuasive if they build upon the established principles of retained EU case law. The TuneIn case is again relevant here.
How so?
The Court of Appeal, while clarifying that a post-Brexit CJEU Grand Chamber judgment on communication to the public, a copyright concept rooted in a harmonized EU directive now retained EU law, was not binding. Found it to be highly persuasive because it represented a natural evolution of extensive pre-Brexit CJEU jurisprudence. It helped understand the trajectory of the law.
Okay, so EUWA 2018 created retained EU law. Pre-Brexit CJEU judgments are binding retained EU case law, subject to cautious departure by senior courts. Post-Brexit CJEU judgments can be regarded, maybe persuasive. Got it. What about the pan-European registered rights, the EUTMs and community designs? These covered the UK before Brexit. What happened to them?
Yeah, this required more direct administrative action to ensure continuity. Couldn't just rely on retained law. The UK government implemented regulations, like the Designs and International Trademarks Amendment, etc., EU Exit Regulations 2019, to protect existing rights holders. Holders of existing registered EUTMs and registered community designs were automatically granted equivalent comparable UK rights at no cost without needing to refile.
Comparable UK rights. What does that mean in practice? A new UK trademark?
Pretty much. An existing registered EUTM was automatically converted into a new equivalent UK trademark on the UK register called a comparable trademark, EU.
Right.
Similarly, registered community designs became comparable UK registered designs. For unregistered community designs, they received equivalent new unregistered design protection under UK law.
So the conversion process ensured that businesses and individuals who had acquired these EU-wide rights didn't lose protection in the UK simply because of Brexit.
Exactly. Preserved vested rights aimed for legal certainty.
That seems like a practical way to handle it. What about the principle of exhaustion of rights? That sounds complicated.
It can be, yeah. It's linked to the single market.
Yeah.
The principle of EDA exhaustion meant that once goods bearing IP rights, like trademarks or patented products, were first put on the market anywhere in the European Economic Area, EEA, which is EU plus Norway, Iceland, Liechtenstein,
Yeah.
by or with consent of the right holder.
Okay.
The right holder's rights were considered exhausted within the entire EVA,
Exhausted mean
meaning they couldn't use their IP rights to stop the further sale or distribution of those specific goods anywhere else within the EEA. Promotes free movement of goods once they're legitimately on the market.
And how did Brexit affect that? Did exhaustion stop?
Well, to maintain existing business models and the flow of goods, the UK decided unilaterally to continue recognizing EEA exhaustion.
Unilaterally?
Yes. This was implemented via the Intellectual Property Exhaustion of Rights, EU Exit Regulations 2019. This means goods first put on the market in the EEA, by or with the consent of the right holder, can still be imported into and circulate freely within the UK without the UK IP right holder being able to stop it based on their UK rights.
So goods from the EEA can still flow freely into the UK based on EEA exhaustion. Is it reciprocal? Can goods first put on the market in the UK flow freely into the EEA based on exhaustion?
Well, that's the key point. The source highlights the lack of reciprocity here.
Oh.
The EU's position is that rights in goods first put on the market only in the UK, outside the EEA, are not considered exhausted within the EU. So while EEA exhaustion applies into the UK exhaustion does not apply into the EU.
That's a notable asymmetry in the post-Brexit trade relationship regarding IP. A big practical impact for businesses exporting from the UK.
It certainly is. And finally, on Brexit, the source confirms that the EPC system is unaffected.
Because it's not an EU agreement.
Exactly. Since the EPC is not an EU agreement, the EPO system of granting European patents, UK, continues exactly as it did before Brexit. The UK remains a member of the EPC independently of its relationship with the EU. Business as usual for the EPO route.
Okay, so the legacy of EU influence is profound. Harmonized national laws are now retained EU law. Pre-Brexit CJEU judgments interpreting that law are binding retained EU case law. Pan-European EUTMs and community designs were converted into comparable UK rights, and the principle of EEA exhaustion is maintained into the UK, albeit without reciprocity. That's a complex but crucial layer on top of the international foundations and UK statutes.
It truly is a layered legal system, lots of moving parts.
This brings us to the final source of UK IP law the source material discusses: case law. The interpretation of all these statutes, regulations, and principles by courts and tribunals. The source says it's vital to understand case law by knowing which tribunal made the decision and in which context. Why is that so important?
This is key, because not all decisions have the same authority, and the specific legal questions being addressed differ depending on whether you're seeking to register a right or enforce it later on. Context matters.
Let's look at the context first. Context 1, application for registration. What happens here?
In this context, a tribunal is assessing whether an application for a registrable right, a patent, trademark, or registered design, meets the specific statutory criteria for that right as laid down in the relevant UK Act or retained EU law.
So, does it qualify? Is it distinctive enough? Novel enough?
Exactly. The focus is purely on registrability requirements. Does it meet the threshold?
And context 2, infringement action.
This is where someone alleges their IP right has been infringed. Someone's copied my invention or used my brand. The tribunal's primary task is to determine if the actions of the alleged infringer meet the criteria for infringement under the relevant statute. But importantly, in the UK, the defendant in an infringement action can often raise a counterclaim challenging the validity of the registered right itself.
So in an infringement case, the court might end up looking at both infringement and whether the right should have been granted in the first place, sort of a two-pronged attack.
Exactly. They might revisit the registrability criteria, was it actually novel back then? But also apply the rules specific to infringement. This means a single case can involve interpreting provisions related to both validity and infringement.
So understanding the context, application, or infringement helps us understand which legal questions are being addressed in a case. Now, which tribunals are we talking about in the UK system? Where do these decisions come from?
Okay. For the initial application context for UK national rights, the main tribunal is the UKIPO, the UK Intellectual Property Office. They have examination divisions for patents and dedicated registries. The Trademarks Registry and the Designs Registry that handle applications for UK national trademarks and registered designs, making decisions on whether they meet the statutory requirements.
So the UKPU is the first port of call for getting UK national rights granted.
Yes. Now, for infringement actions and validity challenges, the main courts are the Patents Court, which is a specialist court within the High Court's Chancery Division,
Patents court.
and the Intellectual Property Enterprise Court, IPEC, formerly known as the Patents County Court.
IPEC, right.
IPEC is designed to handle lower-value IP disputes in a more streamlined and cost-effective way, covering patents, trademarks, designs, and copyright. Makes litigation more accessible in theory.
So UKPU for grant of national rights and the Patents Court or IPEC for litigation, broadly speaking.
Broadly speaking, yes. But as we've discussed, rights effective in the UK also come from non-UK bodies. We can't forget those.
Like the EPO. We mentioned them granting European patents, UK.
Exactly. The EPO grants European patents, UK. As we covered, the judicial organs of the EPO, its boards of appeal and enlarged boards of appeal, interpret the EPC.
And their case law is persuasive for UK courts.
Highly persuasive, yes. Especially for UK courts interpreting the Patents Act in 1977 due to the act's designed to mirror the EPC, as seen in cases like Merrill Dow and Kieran Amgen.
So EPO case law, while not technically binding, strongly influences how the Patents Act is interpreted in UK courts. You need to read EPO decisions, too.
You really do if you're dealing with patents. And before Brexit, the UIPO, formerly OHIM, granted the EUTMs and community designs that were effective in the UK.
Right.
Case law arising from appeals against UIPO decisions, particularly those decided by the General Court and the CJEU, remains important for understanding the principles behind retained EU law related to trademarks and designs and the nature of the comparable UK rights derived from them.
So UIPO appeal decisions still matter for understanding those comparable UK rights?
Yes, they shed light on the underlying principles. And then there's that enormous body of pre-Brexit CJEU case law we talked about.
Which, as we've established, now has binding status as retained EU case law for UK courts, subject to that power of departure by senior courts.
Exactly. This case law primarily arose from two routes. First, preliminary rulings under Article 267 TFEU.
National courts asking the CJEU for guidance.
Yes. National courts throughout the EU, including the UK during membership, could refer questions on the interpretation of EU law, particularly the harmonization directives, to the CJEU for a definitive ruling. This was a major source of case law, especially for the Trademarks Directive.
So national courts asking for clarification generated a wealth of binding interpretation.
Precisely. And second, from appeals from UIPO.
Okay.
As the final appellate body for decisions concerning the registration of EUTMs and community designs after appeals through the General Court, the CJEU generated significant case law interpreting the EU regulations governing these rights.
So the CJEU built up a massive body of IP case law before Brexit, both by interpreting directives at the request of national courts and by hearing appeals related to the pan-European rights, a huge legacy of judgments.
Yes. And while new CJEU decisions aren't binding, as we saw in TuneIn, UK courts can and do have regard to them, especially when they build upon existing retained EU case law.
Right.
So understanding the tribunal and context of these pre-Brexit decisions, were they preliminary rulings interpreting a directive or appeals from UIPO interpreting a regulation, helps gauge their specific relevance and binding status for interpreting UK IP law today, much of which is retained EU law. Knowing the source of the judgment matters.
This has been a truly deep dive into the foundations. Wow, we've seen just how interconnected and layered the sources of UK IP law are. It's certainly not simple.
It's far from a simple picture. It's a confluence of international agreements, those foundational WIPO treaties like Paris, Bern, and Rome, plus the powerful trade-related agreement perhaps. Then there are important regional systems like the EPC for patents.
All of this feeding into UK domestic legislation, the core statutes like the RDA 1949, Patents Act 1977, CDPA 1988, and Trademarks Act 1994, which were largely enacted or amended to implement these external obligations.
And then the massive influence of EU law during the UK's membership, bringing harmonization directives that reshaped national laws and creating pan-European rights like the EUTM and community design.
And the crucial impact of Brexit, managed by the EUWA 2018, resulting in retained EU law, binding pre-Brexit CJEU judgments, retained EU case law, the conversion of those EU-wide rights into comparable UK rights, and the nuances of EEA exhaustion. So much to remember there.
And finally, the constant interpretation and evolution through case law from the EK tribunals like the UKO, Patents Court, and IPEC, and the significant persuasive or binding influence of case law from the EPO and the pre-Brexit CJEU. It's a dynamic system.
Our goal here wasn't just to give you a list, but to illustrate how these pieces fit together, how a convention signed in the 19th century like Paris still influences modern UK trademark law, how joining a patent convention EPC shaped the Patents Act 1977, how the drive for an EU single market led to wholesale changes in UK law that remain today as retained EU law,
Mhm.
and how courts navigate this complex landscape, relying on case law from multiple jurisdictions.
Understanding these sources, their origins, their relationships, their legal status today is absolutely foundational. It's the bedrock for understanding why the specific rules for copyright duration, patentability criteria, or trademark infringement are what they are,
Right.
which is essential knowledge for success in later chapters and, of course, for your exams.
For all of you preparing for your exams, remember the importance of solidifying your understanding of these foundational elements. It's worth spending time on this.
Definitely. Revisit the key conventions: Paris, Bern, Rome, EES, EPC, the principal UK statutes, RDA 1949, Patents Act 1977, CDPA 1988, Trademarks Act 1994,
Yeah.
the key EU mechanisms and their Brexit outcome, harmonization directives, pan-European rights, EUWO 2018, retained EU law, EEA exhaustion, comparable UK rights, status of CJ EU judgments.
Don't forget those key cases.
And those illustrative cases, like Merrill Dow, Kieran Amgen, TuneIn, don't just memorize names. Understand the principle each represents and how it fits into the bigger picture.
Yeah.
Come back to this overview periodically as you study the specifics of each right. Context is everything.
Building this strong base here will make everything else much clearer. And as we wrap up this deep dive, let's leave you with a thought to ponder, drawing from this intricate map of influences. Given the constant evolution of technology and creative expression, the layered nature of these sources, and the ongoing process within the UK courts of interpreting and potentially shaping that retained EU case law, how might the very sources and structure of UK intellectual property law continue to transform in the years ahead? It's clearly a legal landscape that never stands still.
A dynamic picture indeed. Always something changing.
Thank you for joining us for this deep dive into the sources of UK intellectual property law. We truly hope it's given you a valuable foundation.
And again, all the very best of luck with your studies and exams.
We'll catch you on the next deep dive.